Okay. Welcome, everyone. This is the new joint pro between the Arbitration and Dispute Settlement of Sciences Po and School of International Arbitration, University of London, and our friend Stavros Regulakis, who unfortunately cannot join us today. He is in our mind. This program, this joint efforts with Queen Mary activity, and I hope that will be for many years in the future. This year, additionally, we are starting with the new moot competition with the Sciences Po Law School, Queen Mary, but also NYU and the National University of Singapore. And this time, we have also the support as ever of the Sciences Po Arbitration Society, and thanks for all the members, in particular its president, Alexandra Senegasnik. And as was certainly not, I would like to thank Fernando Mantilla and Leland Watkins and all the people in Leland Watkins, in particular Esperanza, who has really worked very hard to make possible this, that like a dream after all the of the COVID restrictions. And this year, we are here to discuss or to try to answer a question, which is, in which extent international contributes to the harmonization of the law. And I've organized two panels with full speakers. The first one on international commercial arbitration and the second one on investment arbitration. The idea is to make in a particular way, because it is new modernity, is hybrid, and we have some speakers from different parts of the world, in Europe, in Latin America, in North America, and we have the other, as you can see, here in Paris. The first panel will be moderated by Constance Castres de Saint-Martin. Constance, after a long time at the ICC as a deputy counsel, now started a private practice, and we wishes her all the best in the new step in his professional life. And the second panel will be moderated by myself. So quickly, because we don't have much time, I will pass the mic to Constance and welcome all of you. There are the students of Sciences Po, but also some other people, and I really thank you in presence here. And this is an activity within the context of the Paris Arbitration Week, and maybe it will be one of the best arbitration weeks. We are lucky enough to be here today. Constance.
Thank you, Diego, and welcome everyone. So let me introduce, my speakers in running order. This panel will deal only with commercial arbitration. And Diego's panel is going to deal with investment arbitration. So my speakers will Audley Sheppard, that you know, of course, a partner at Clifford Chance, London, and chair of International Arbitration Advisory Board. Marina Matousekova, French partner at Castres Partners. José Ricardo Feris, former Deputy Secretary General at the ICC and Squire Patent Box. And Eleonora Coelho, who is a Brazilian lawyer based in Sao Paulo, is the current of the Center for Arbitration and Mediation of the Chamber of Commerce, Brazil, Canada. She's also a professor at Sciences Po. I thank them for accepting to join this event. And we actually have invited them to tackle the following topic: harmonization through arbitration. More precisely, we have invited them to discuss the following problematic. If we perceive arbitration as a market, are we witnessing an harmonization of the players, meaning the arbitrators? And are we witnessing an harmonization of the product, meaning the awards? The first panel will address the first part. Audley will plead for the positive and Marina for the negative. The second subpanel will address this problematic. José will plead for the positive and Eleonora for the negative. Audley, the floor is yours.
Thank you very much, Constance and co-panelists, ladies and gentlemen. As you've just heard, the topic of our debate is, are we witnessing an harmonization of the arbitrators? Marina and I will focus on commercial contract arbitrators as opposed to investment treaty arbitration, which you'll hear about later. And as you heard, as I was introduced, I will speak in support of the motion. Yes, we are witnessing a harmonization of commercial arbitrators. To begin with, what do we mean? What do we understand by harmonization? Well, homogeneity, sameness. And I expect you need little persuasion and that you already agree with me. The evidence is overwhelming. But I will leave you in no doubt. I have 10 points I wish to make. First, when was the last time you appointed a non-lawyer? The reality is that the vast majority of commercial arbitrators are lawyers. The claimant thinks it has a strong factual and legal case and believes a good lawyer will see that and decide in its favor. The respondent doesn't want to be outgunned by a clever and articulate lawyer on the tribunal appointed by the other side, so also appoints a lawyer. And then those two appoint another lawyer as chair. And there it is, 3 lawyers, harmonization of the tribunal. Very occasionally, a party will appoint an engineer, but often someone with dual qualifications, law and engineering, or even very occasionally an accountant. But I'm sure you will agree with me that that is unusual, the exception that proves the rule. Second, nearly all the lawyers appointed tribunals have experience of arbitration, with many prior appointments and acting as counsel. Where are the non-arbitration specialists, such as transactional lawyers? Third, many arbitrators, especially prominent ones, are involved in the same organizations, attend the same events. We see them at the IBA Arbitration Day. We see them at the arbitration sessions of the week-long IBA conference. We see them at the ICA conference. We see them at the arbitration session at the London International Disputes Week. We see them this week at Paris. We see them in the Hong Kong Arbitration Week. We see them at the Vismut, etc., etc., etc. And wherever in the world these events take place, the same themes are discussed. They hear the same speeches, which influence their thinking. The result is sameness in thinking about arbitration by these arbitrators. My fourth point is that while it is not yet the norm, there is a trend that is gaining momentum. Increasingly, advocates and consequently arbitrators have studied arbitration at university, even at undergraduate level. And that was never the case in the past. And more have done LLMs at such distinguished institutions as Queen Mary and Sciences Po. This gives rise to sameness. Fifth, nearly all the lawyers appointed tribunals are members of law firms or in England are barristers. Fewer and fewer full-time academics are appointed. I am replacing our good friend Stavros Brikolakis, who is principally a professor at Queen Mary, but he is an exception. And even he is now also a member of a barristers' chambers in London. Sixthly, and related to the last point, where are former in-house counsel? Very few become arbitrators. You can, of course, think of a few, but only a few, and they are the exception. Seventh, in Europe, there is a sad absence of regional and racial diversity. How often do you see arbitrators appointed from Africa? Now, it will be said against me that there is now much better gender diversity. The homogeneity of arbitrators being white, male, and stale is changing. I acknowledge that there have been improvements, but my counter-argument, an eighth point, is that these changes are mainly due to the institutions. The parties themselves still favor male and stale. If we look at the statistics of the ICC in 2020, the parties appointed female arbitrators only 16% of the time. We have a long way to go before we can say that there isn't a preference by parties for male arbitrators, giving rise to sameness, harmonization. My ninth point is that there is a sameness about the way that arbitrators approach the case and conduct themselves. The next debaters will address harmonization of procedures, so I don't want to cover the same ground. My point is a slightly different one. I totally agree that we are witnessing a harmonization of procedures. My point is that this causes a sameness in the arbitrators themselves. For example, whatever their background, they all meet the criteria of the IBA guidelines on conflicts of interest. Whatever their background, they issue similar procedural orders, number one. Whatever their background, they're all accepting of memorial style submissions. Whatever their background, they're all accepting to a greater or lesser extent document production in accordance with the IBA rules of evidence. Whatever their background, they're accepting of common law style cross-examination. And whatever their background, they write awards the way the ICC prescribes with a lengthy recitation of the procedural history. Very few arbitrators stand out for approaching arbitral procedure in a different way. And my 10th point is a related one, and again, this will be touched on later. There is a sameness in legal reasoning. I'm sure that you have had cases where you have wanted to appoint a black letter lawyer or not. But in my experience, it is actually very hard to label commercial arbitrators. My experience of sitting on tribunals is that some co-arbitrators whom I expected would be more black letter have not been. The writing of awards nudges arbitrators towards homogeneity. The chair will try to find a consensus, which may well involve compromise by the arbitrators. The black letter arbitrator may be persuaded to be a little less dogmatic. The good faith proponent may be persuaded to apply the party's bargain as written. The outcome may be more or less the same, irrespective of the legal tradition of the arbitrators. And moreover, dissents are discouraged. In conclusion, I'm sure you didn't need persuading, but I trust I have given you the backup to support your instinct that we are witnessing the harmonization of arbitrators. Maybe like me, you inferred in the question an implicit criticism of what we are witnessing. I would refute that criticism or disapproval. What parties want is predictability, and they can make their decisions accordingly. They and their advisors want a high degree of predictability as to how any arbitration will be conducted. That requires consistency, and the foundation of that is homogeneity in the decision makers. Our clients do not want characters, outliers, mavericks in their arbitrators. Harmonization of commercial arbitrators is a good thing. Thank you very much.
Thank you, Audley. Marina? Maybe we could do a sound check. Audley, can you hear Marina?
Yes. So on that issue, I slightly disagree with Audley. I do not believe that there is an homogeneity today amongst arbitrators. And I think that in order to get mandates today, you have to sell your specificities. And in order to illustrate my position, it doesn't work, sorry. Okay, sorry. I wish to first make two remarks on the evolution of the arbitrators world in the past 20 years. Is it okay? Yeah. So the first remark is that the arbitrators world has moved from a very concentrated pool of individuals to a real market of arbitrator. We used to have a caste of white, old men, mainly from Western Europe or North America, who used to perform the arbitrator activity on an occasion, occasionally. Those people were chosen for their outstanding reputation, and among them, they constituted a close and very cohesive club, and they appointed each other within that club. So this club still exists. However, with the increase of arbitration cases, we today have a very larger pool of actors. And I would say that the arbitrators world has democratized and is to a certain extent standardized. So in other words, you do not need today to be Professor Bertolt Goldman if you want to sit as an arbitrator. And I think there are four main characteristics of this new arbitrators world. It is very global. We've seen in the recent years the boom of arbitration in emerging countries, such as in Africa and in Asia, and an increasing number of arbitration cases worldwide. It is a very specialized and segmented market. You have many arbitration. You will have investment arbitration versus commercial arbitration, and within commercial arbitration, we will have many subcategories: oil and gas, construction, maritime, and so on. And then you have the subcategories. In the oil and gas sector, you may have people who deal only with gas pricing dispute, for instance. Third characteristic, it is the world that is more and more professionalized. More and more people can live today of their arbitration activity and earn their source of revenue from that activity only. And we've seen a lot of arbitrators boutique boomings in those last years. And the last characteristic is competition. There is nowadays more and more competition between the arbitrators. And the second remark regarding the evolution of the market of arbitrators is that there are huge efforts being done to promote diversity. And the Queen Mary survey is very interesting in this regard. So first, we have actions from arbitral institutions who really try to promote women, younger, and ethnically diverse candidates. And regarding women, I have slightly different numbers from the ICC. I understand that before the pledge, they used to have less than 20% of female appointment. After the pledge, it is now 37%. I have around myself a lot of young people who work in large firms and who are getting their first appointment as arbitrator by the institution. And also, I have had recently a very big multi-party African case in which the party could not agree on the arbitrator, and the ICC appointed 2 African co-arbitrators and a famous French president. So I think the institutions are doing the job toward diversity. Then we have a lot of prestigious law schools, such as Sciences Po or Queen Mary, who have exchange programs with schools in jurisdiction with less culture of arbitration. Also, we have law firms engaging in mentorship programs to promote the education of younger and diverse candidates. We also have a lot of dedicated working groups who defend, who are very active and defend certain minorities, such as arbitral women or the African Arbitration Association. And they work on dedicated policy texts, such as the Pledge or as African Promise, which, in my opinion, create a moral obligation on the consumer of arbitration. And even if today we still have some conservatism from the client, who are responsible for 75% of the appointments, I think there is a real awareness of the necessity to change things. And I do believe, I'm more optimistic than Audley in this regard. I do believe that there will be a change and more diversity, gender diversity, generational diversity, and also ethnical diversity, because this is the only way to respond to the criticism of arbitration as a mafia or as a Western justice. So it's really necessary for the very legitimacy of the arbitration. And I think there is no alternative. So now, with those 2 remarks in mind, and I will come to the core of the issue, how can we get appointment in this broader and more competitive market? And it's interesting in this regard to see the survey, which set the criteria on the basis of which lawyer and their counsel, parties and their counsel will appoint arbitrators. And all the survey says the same thing. The main criteria is experience. So the basic requirement is experience in the management of arbitration. So of course, what is really necessary is a good education and a background in arbitration, because we are talking about the function to judge, which may not be left to amateurs. So of course, for younger people, if you can sit as a secretary of the tribunal, this is useful. But in any case, more and more institutions will give the opportunity to people who have some solid experience. In general, clients will require previous experience as an arbitrator, but this is not enough. Today, clients will require a specific expertise in similar cases, a sectorial expertise. So they will want to know whether you have done construction arbitration for the construction of this kind of plants, and they will eventually want to know whether you stand more on the side of the client or of the contractor. Then client will also demand a certain familiarity with the cultural context and with the languages at stake. And finally, they will often require some knowledge of the applicable law. And very often they require all that together. This is the very famous ship with 5 legs, as we call it. Now, there is also another factor for which an arbitrator may be chosen, which is the way it tackles certain specific legal issues. So this is very much subtle and subjective as a criteria. You will look at the predisposition of an arbitrator towards certain procedural or merit issues. I will give you an example. If you want to attract in an arbitration a non-signatory of an arbitration agreement that has participated to the conclusion of the contract, you may want to designate a French arbitrator that will be sensitive to the extension theories rather than an English one. On the contrary, if your case is very strong on the very literal interpretation of a contract, rather than on good faith, you may prefer an English arbitrator rather than a Latin one. And we have to keep in mind that one of the main advantages of arbitration is the possibility to choose your arbitrator. And this is a very powerful strategic tool. So when you designate an arbitrator, it doesn't mean that you buy for a solution, but you want to be sure that he will hear and properly defend your argument. You want to maximize the chance of winning your case. So sophisticated clients and counsel, we really look at all those criteria when selecting an arbitrator. And as a conclusion, I believe that arbitrator must really, are really chosen for their specific background, specific sensitivity, specific experiences. And I think we are all different. Even if we spend a few years on the same banks in a university, and even if we all apply the same rituals in arbitration proceedings, I think we are very much influenced by our personal, legal, and professional background. The person you have met, your mentors, the case you have gone through. So when it comes to ruling on the cases, we come with our personal background, and I don't think there is an homogeneous result systematically. Another interesting point is, how do client and counsel prospect arbitrators? Traditionally, in a world that was marked with confidentiality, they used to proceed by person-to-person inquiries, word to mouth. And really, it is a fact. Clients do speak between themselves about the qualities of arbitrators they encounter. And also, they call their lawyer. I can testify about that. Also, some more sophisticated client would proceed to an ad hoc research on the publication of the arbitrator. But nowadays, things are changing a lot in this regard, with the promotion of transparency and the rise of artificial intelligence. We today have very powerful analytical tools that may bring to light the past works of an arbitrator. So those tools, they collect information that are available from the institution on the past cases that were dealt with by the arbitrator. They will ask the arbitrator to fill some questionnaire on their practice, and they will collect publication and so on. And then with a click, you have access to all that. And so when you do your check, you can have all the information available. So it's a world where everything becomes visible, and this is a bit frightening, because on one side it's positive, because I think it may enhance the visibility of unknown, very experienced candidates. But on the other side, it puts a label on certain arbitrators, sometimes beyond their will, based on past cases. And to conclude, I would say that in this very transparent and competitive market, arbitrators should act in a very proactive manner as entrepreneurs. They should really define their marketing and communication strategy to control their image. So today, it's really part of the arbitrator's job to go to the conferences, to build a network, to be visible, and to convey messages on what their strengths and specificities are. And if I have to give an advice to a young generation who wish to become arbitrator, I would say be open, be curious, but cultivate your interests and your specificities very early. Thank you.
Thank you so much, Marina, and thank you for all the tips for everyone listening to us. Do we have any questions so far from the audience? Yes?
We have a question from the audience online.
Oh, great. Can you read it, maybe? Thank you.
Okay. So we have a question from an anonymous attendee who asks the following. Hi, thank you for the very interesting debate. My question is related to the challenge of arbitrators. Do you believe that this harmonization can be used as grounds for challenge, mostly when looking for more subjective aspects, such as friendship between arbitrator and counsel?
Interesting one. Would you like to start, Audley?
Sure. Well, thank you. A very, very good question. And I think it touches upon a point that we're all familiar with, but it's extremely difficult to address. And the IBA cannot address it. National law cannot address it, is to what are the unconscious bias effects of friendship? The IBA looks at the other end of the spectrum and says that you should disclose if there's enmity between an arbitrator and counsel. But if there are no objective connections, being in the same law firm or such like, there's no requirement of disclosure of friendship, or it may be acquaintance but great respect for the writing of a particular counsel that appears before you, if they do that. And yes, I think it's difficult. In answer to your question, I think the answer has to be no. Friendship can't be a basis for, unless it goes too far, unless your families consistently go on holiday together and that sort of thing. But I think professional friendships is not a ground for challenging an arbitrator, but it requires arbitrators to act with the highest professionalism when they have someone appearing as counsel whom they know and like, or whom they know and don't like, treating everyone the same and addressing the legal argument and the factual evidence, and don't let the people make that in any more complicated or confusing what your role is.
Thank you, Audley. Marina, would you like to add something? Yes?
I agree that friendship should not be a ground for challenge. I mean, even if the market is larger, it's still a community, so people know each other. I think professional arbitrators will not engage in ex parte talks. And what happens when two friends are arbitrators in the same, they avoid seeing each other for lunch simply, and they behave in a professional matter. There is a proof, of course, of ex parte, and yes, this is different. But friendship per se, I do not think it should be something that could be a ground for a challenge.
Thank you very much. I think it's time for us to listen to our next speakers. Audley, you've spoken about the predictability. Well, harmonization of arbitrators could lead to an harmonization of awards. So maybe let's listen to José first.
So let me see if this works. I don't know if it works. Yeah, it does. Okay, I'll stay with this then. Well, thanks for the invitation. It's good to be wearing a suit for the first time in 2 years. Well, a full suit, of course. We've all wearing jackets, but not necessarily pants. Anyway, a pleasure to be here discussing this great topic. The way in which Eleonora and I are going to address is more like a conversation. So we have chosen 3 topics to discuss, 3 subtopics, and we're going to finish with the topic of scrutiny of awards. But generally speaking, we'll first address harmonization. Is it desirable or not? Then we will address the question of precedents. Is it desirable? What is the role of precedent in international arbitration? Because it is related to the award, harmonization of awards. And then we're going to speak about scrutiny of awards, which, as you may know, some institutions have it and some institutions don't. And it is often discussed as to whether that is a good thing or not for awards. So in terms of whether harmonization is desirable, I'm going to be discussing the positive aspects of all of this. Eleonora is going to speak about the negative aspects. These are roles that have been imposed on us. So we're going to play the role. Probably the answers are not going to be on either side, probably in the middle, but we were not allowed to do baby splitting as it happens in arbitration. So we'll just take one side. So is it desirable? I think I have the easy answer in this part of the exercise. I think yes, for one one reason. I'm not gonna give more reasons. I think legal certainty, which is one of the aspects that Audley touched upon, is perhaps the main reason why we seek harmonization in international arbitration. When we speak to our clients, the clients want to know how the arbitration is going to be conducted. What is it going to happen? And when you look at statistics such as the ones Queen Mary publish regularly, you will see that one aspect that is key for in some jurisdictions for users to choose courts, local courts, is legal certainty. Lawyers know how the courts operate. Lawyers actually know how the judges decide, and that is very important. So in some instances, users prefer local courts because of that. They are afraid as to what can happen in arbitration, right? So in arbitration, we have rules, but the rules are usually very general. So the legal community, the arbitration community has made this effort of adopting more specific rules. The IBA has played a very important role for specific topics within the procedure that we actually want arbitrators to apply. We don't want surprises. When you're counsel, you have advised your client as how this is going to happen. You don't want surprises. And I can give you an example that I am living now. Normally, the way an arbitration goes is that you file a request for arbitration and an answer to the request, then you have a case management conference, then the real arbitration commences with a statement of claim and a statement of reply. There may be some exchange of documents at some point, and then a hearing, and so on and so forth. That's the arbitration that you sell your client, right? Well, I mean, this arbitration, we're representing a Latin American client, and we find ourselves in the institution of an Eastern European country, which is relatively unknown to the Latin American world. I happen to know of it because of my practice, but it is not very known. So of course, I advised the client. I said, well, look, we may have a few surprises. So we file our answer to the request for arbitration, and we just received an order a few days ago saying, okay, now we have a hearing on the 15th of October, and that's it. You know, we have everything we want. And of course, the client is very scared, right? This is not the kind of surprise that you expect. And this is why actually we want harmonization. So this is my pitch for harmonization. Eleonora.
Thank you very much for the invitation, for being here today. Unfortunately, I couldn't be there in person because I was only fully vaccinated this weekend, but it's a pleasure to see you all here. And the answer for the question if standardization or harmonization would be desirable, it is, of course not. Each arbitration is unique. And I know that José Ricardo would agree with me. He could offer his own opinion because, you know, the approach one size fits all does not match with arbitration. And why is that? Because arbitration, one of the cornerstones of arbitration is the party autonomy and the flexibility. And of course, you can have legal certainty using your flexibility and the party autonomy in order to decide which proceedings you want to establish in your case, which would be the most suitable rules to be applicable to your case. And even in cases in which they seem to be very similar, there are differences, and parties seek tailor-made proceedings. They seek tailor-made decisions. And that's why I'm totally against the harmonization. And also, I think that one of the good grounds of not accepting the harmonization is that it would transform us into artificial intelligence. Because if we could harmonize the proceedings, harmonize the decisions, so we could be replaced by artificial intelligence. So I think that the humanization of arbitration is towards the non-harmonization of the arbitration. That's my point of view.
Very good. So we're going to move on to the second topic of discussion, which is whether we should allow for the idea that there is precedent in international arbitration. Is it desirable for arbitral awards to have the role of precedent? And here again, I think I have the easy answer to that, which is yes. And I'm going to give you 2 examples. I know we're not supposed to speak about investment arbitration. I think in investment arbitration, this is more or less already the truth. Even those arbitrators that say that investment arbitration awards do not constitute precedent, they will cite and they will read the previous awards. Why? Because they want to be comforted that the decision that they're taking is a decision that others have also taken. And counsel, they will plead those precedents also because a question of responsibility, but also because they want to be persuasive. They want to say, hey, it's not me who says it. It's other tribunals have already decided this way. But even in commercial arbitration, where we still don't have enough awards published, those that are published, I can tell you we're going to cite them because, again, we want to be persuasive. And particularly when it comes to, let's say, specialized fields such as construction, there are FIDIC contracts that are submitted to arbitration. Those awards have been published. We will try to see how certain FIDIC clauses have been interpreted already when we do construction arbitrations. But we also cite awards on arbitration-related topics, such as preliminary measures, issues such as non-signatories, those types of issues, and even in topics such as M&A, very often you will see that contracts are very similar. Normally, contracts are being signed. They come out of a model that was designed in New York somewhere, and those contracts very often submitted to a particular law. So you will try to see how arbitrators have interpreted certain clauses in those contracts, and you will want to persuade the arbitral tribunal that the decision that others arbitrators have taken is the correct one. And again, comes back to the topic that I just mentioned before, which is legal certainty. So this will add again to legal certainty and therefore to the legitimacy of international arbitration. Eleonora, I know it's going to be difficult for you, but
it's so easy because the answer is, what is precedent in international arbitration? There's no such a concept of precedent in international arbitration because the people they're not arbitrators. They sit as arbitrator, and each decision is unique, and they're not part of a judiciary. They're not obliged to follow other decisions or even to look at different decisions. And you can ask me, oh, Eleonora, in construction cases or energy cases in which they're so similar and cases, but like I deal with, for instance, energy cases in the same power plant constructions, for instance, here in Brazil, in the same areas. And in a few cases, the difference is totally opposite. Why is that? Because, for instance, the soil can be completely different, the workers can be different, the company is different. So, precedent, this is really does not exist and is really it's useless in international arbitration because there are major differences between the nature of the state judge and the arbitrator. Judges, they're part of an institution, and therefore they should worry about the harmonization of their decisions. And as I said before, one of the advantages of arbitration is to seek a tailor-made decision. That's the real expectation of the parties. They do not seek for legal certainty in an amount that would harm their free will, their party autonomy in order to have a tailor-made decision. Also, the existence of precedent in arbitration could lead to something that is really, really harmful, Jose Ricardo, you may agree with me, like arbitration for shopping. You know, it's very complicated. When you know how an arbitrator will decide, you can pick that arbitrator due to his or her precedent position in certain issues. And this could be really harmful to international commercial arbitration. Also, the idea of precedents in international arbitration can harm something that is really sacred for international arbitration, which is confidentiality. We know that this is, and researches, Queen Mary researches shows that confidentiality is something that the parties take into account when choosing arbitration. So in my view, also, there is no such a concept of precedent, and even if there was, it's not useful, and it can cause harm to the cornerstones of arbitration and the reason why parties choose arbitration for solving their disputes.
Okay, well, we're not making any progress, Eleonora and I, so let's go to the third topic and see whether we can make any progress in scrutiny. It's a very easy topic for me. Having worked at the ICC for 13 years, I can only speak about it in the positive aspects. And I'm tempted to say today that when I was a young lawyer wanting to break into arbitration, a very old, wise arbitration practitioner called Fernando Mantilla, I don't know if you've heard about him, told me something about scrutiny. He says, look, scrutiny is something that is done to make bad awards enforceable. And I think he still believes in that thing. But precisely, I think that is the point about scrutiny. Because we all come into arbitration and we all know that we need to accept the result. So that is a risk that we have already taken. And we know that depending on the arbitrators you get, your award is going to be of less or more or higher quality, lesser or higher quality, right? So quality is a very important aspect of the award. And why is quality important? Quality is important in order to satisfy the users. Have they been heard? Have their case been carefully analyzed? And very often when you sit as arbitrator, you're into the case, right? And certain things that are very obvious to you, right, may not be that obvious for someone else, right? You tend to sometimes decide an issue very quickly because you know the case by heart by the time you draft the award, and it seems very obvious to you. But then someone else looks at it and sees, well, you know, you want to explain, you want to elaborate a little bit further on this. And the effect that has, it may not change the decision, it may not change the outcome, but the user, when reading the award, will feel better, will think, okay, they heard me, they considered my arguments, I spent a lot of time and a lot of money, justice was done, you know? And sometimes that feeling of having the feeling that you were heard is the difference between you accepting the award and voluntarily complying with it, or trying to set aside the award before complying with it. So, and that is what is achieved with scrutiny, having different eyes looking at the same case from an outside perspective and trying to help you, you know, perhaps change or improve certain things. The other reason why I like scrutiny, and now that I am on this side of the world, sitting as an arbitrator, I actually like it. Sometimes I call the ICC and say, look, you know, please look at this issue carefully, because the truth is that cases that go to arbitration are never the easy cases. That's why they go to arbitration. There are always some gray areas. And sometimes you take your decision, but you want to have that comfort that other people looked at it and other people feel that the decision is fair. And very often you have to sit in different jurisdictions. Recently, I rendered an award. I was sitting in Stockholm, right? And I know that the Swedish Arbitration Acts have certain particularities, certain things that you have to include in your awards. And, you know, it's good that someone looks at it and tells you whether you've done it right or wrong. So for all those reasons, I think that scrutiny again helps achieving this legal certainty that we're speaking about, and I think it is an important part of harmonization. And again, I think it's a very positive aspect. Eleonora.
I couldn't disagree more. If my colleague José Ricardo was an arbitrator, he would be completely conflicted. I would challenge his say here, because he was, of course, in charge of scrutiny in ICC for many years. So, of course, that he's completely conflicted. So, and unfortunately, I can change him. So I will only show you the clear arguments against his position here. Of course, that parties want enforceable awards, but they don't want standardized awards. They want enforceable awards. And who says that scrutiny makes the award more enforceable? Scrutiny is focused on formal aspects of the awards, and they do not render this award more enforceable or not. On the opposite, sometimes they create difficulties with the arbitrator. I have faced situations in which the arbitrators preferred to have the award in a certain way expressed, and scrutiny determined that the arbitrators change their position, and what to do and how to deal with this conflict when it happens between arbitrators and the court of ICC, for instance, scrutiny. I don't know if there are other institutions that proceed with scrutiny. Also, scrutiny takes too long. It costs a lot, and it does not grant legal certainty. It only focuses on useless details, and arbitrators, they are chosen by the parties because of their legal backgrounds, because of their preparation, and they're really well prepared to render an enforceable award. And the scrutiny will only create problems and costs that is totally against the efficiency that we seek in international arbitration. That's my position.
Very good.
Thank you so much for this very enthusiastic presentations. Do you have any questions in the room, the audience, virtually?
Your comment.
We do have one. I think we have maybe time for one question.
Okay, so we have a question from Frank Tassin. He asks, should the increased harmonization / standardization of certain phases of international proceedings not be? So I believe he's asking on the impact of standardization on costs. On costs of the proceeding.
I'm sorry, I couldn't listen to the question.
So the question, Eleonora, is whether harmonization increases the costs of arbitration. I'm sure you're going to say yes.
Of course. Of course, the advantage of tailor-made decisions and the creativity of arbitrators in order to seek for an efficient solution to each case is, as I said, one of the most important and valuable advantage of international arbitration.
Yes.
Okay, one last question. Thank you.
Well, I'm trying to think of an answer, but of course, the question is not so much the costs. The question is, again, legal certainty. And when you want legal certainty, you take certain risks, and costs is one of them. And therefore, I don't think costs is in the lawyer's mind when they wish to have a harmonized procedure, a procedure that they know how it's going to take place.
If you allow me, I will speak without the mask. Thank you very much for the debates, both debates. And of course, I know that your positions probably have been a bit forced to have a positive or negative one, but I just wanted to come back to the precedent and to agree more with Eleonora. But From the point of view of someone who edited on a book on the precedent in international law, to which my neighbor on the right participated about the theme of arbitration, I think that it shouldn't be forget that precedent is more a legal technique than anything else. And we should also have in mind the distinction when you act as a counsel, you say that you needed to have a few cases just to make your point, etc. But this is just legal arguments, doesn't mean that it acts or that it will have the effect of a precedent. So we should distinguish the position of the counsel, of course, who needs also to cite some legal doctrine that will help, and that doesn't, of course, the thinking of an author will be followed. So as a counsel, I understand very much that all the precedents all the decisions should be quoted. But for the arbitrators, I think that in international commercial arbitration, there's nothing such as precedents. You should be clearly distinguish the cases, and you may quote in an arbitral award a decision, but that doesn't mean that you think that this decision is a precedent. It's something different, just to serve as a legal reasoning and to have the effect of a precedent. Thank you.
Yeah, thank you for the comment, and perhaps to react to that, and perhaps maybe here take off our hats, and maybe we can finish with an agreement with Eleonora. The truth is that in commercial arbitration, the most important aspect of it is the facts. That's where we spend most time, is not just presenting the facts to the tribunal, but also in writing and orally. Hearings are about facts. There's very little law discussed in the hearings. And that tells you a lot about arbitration. I would say that very often you are writing an award, or you receive an award, and you see very little law cited in the award. You cite the contract, you make reference to the facts, but the law is almost irrelevant in many, I would say, I would dare to say more than 80% of the awards that I've read, the law was not a game changer. So clearly that tells you a lot. If that is the case, then these awards cannot become precedent, because the facts are totally different in every case. So perhaps, Eleonora, there you go. You beat me.
Yeah, taking off the hat now, and manifesting my own opinion. I agree with you, José, and of course that each case is unique and the facts are different, and they're really important. And one of the advantages of arbitration is really seeking the real truth and really what happened in each case. And we have many different tools in arbitration. But as the person who asked the question mentioned, also it would be important, and I defend that more awards could be published. Of course, that when in their confidential proceedings, you would hide the name of the parties and the important information in order to identify that case. But ICC is doing that. Us in CBC, we have had a task force studying the importance of transparency and publication. And of course, it happens not only in the merits, but also in the procedure aspects, how to deal with matters. So I think it would be, as José said, in the end, we're going to meet each other in the middle of the way.
Thank you so much. Thank you to Audley, Marina, José, and Eleonora. I think it's time for us to move to investment arbitration. Thank you.
Yeah.
So I ask everyone to remain in your places while we set the next panel.
Well, thank you for staying here. We will start with the second panel, the second and last panel, dealing with investment arbitration. For that, we have really a dream team. And I'm very happy to share this scene with these friends. Unfortunately, only one here, a very good one, but only one here. And the other three are participating remotely. They are Ina Popova, who is a partner in Devil's Clinton in New York. Ina is a polyglot acting in arbitration, either as a counsel or as an arbitrator in all continents, in Latin America, in Africa, here in Europe, and in the US, of course. Andrés Jana is a partner in Borfil Mir Alvarez Jana in Santiago, Chile. He's a quite famous arbitrator in many fields, and also a lawyer in cases before the ICJ. And he's currently vice president of the ICC Court of International Arbitration, and also the president of the working group of international commercial arbitration of UNCITRAL. And we have also Professor Giuditta Cordero-Moss, who is a professor in the University of Oslo and has acted in many arbitrators, as in particular as an arbitrator. But in a former life, she was also a negotiator of contracts, and in particular for Fiat, representing Fiat in many countries. And she is also member of the ICC Court and also member of the Consiglio Arbitrale of the Milano Chamber of Arbitration. And Fernando, here, who is our host today, and who is not only a partner in Latin Watkins, but additionally, he is the global leader or the co-chair of the global practice of international commercial arbitration in this firm. So our idea is slightly different from the previous previous panel, but also we will have positions, not necessarily the personal positions, but positions clearly attached to everyone. And we will have two teams. One team composed of Ina Popova and Andrés Jana, who are really, and they feel like this, they are really in favor of demonstrating here that arbitration is crucial for the harmonization of arbitration law and the law in general. And we have the opposite view. We will have the opposite view of Giuditta and Fernando, who think that all that is just bullshit and that is nothing to do. Arbitration and harmonization really is not a couple, or at least a good couple. So the idea is to have at the beginning 15 minutes each team to present their points, and then we will have short periods of time for reply and rejoinder. If we have some remaining time, maybe we can receive some questions by internet or here in the room. So please, Ina and Andrés have the floor.
Thank you very much, Diego. Thank you, everyone. So, like good civil lawyers, we begin with defining the term. Harmonization derives from harmony, from the Old Latin and Greek harmonia, harmos, which means literally fitting together. And the ordinary meaning of the term is to add different notes to a melody so that together they produce a concordant and pleasing sound. In private law, where the term is more frequent, it's understood as the process of ensuring that rules that have the same origin are interpreted in accordance with the same principles. And since we are in Paris after all, Cornu's vocabulaire juridique defines it as un simple rapprochement entre deux ou plusieurs systèmes juridiques, a coming together of one or more legal systems. Now, in both the legal and the ordinary meaning, harmonization is not unification, which means to make one and the same, from uni facere. Harmonization is instead consistency and complementarity. So to be clear, we're not talking about binding precedent, but about giving due consideration to past cases and developing the law in a deliberate and consistent manner. Each individual note in a harmony is distinct and different, but they work together to make one and the same melody. And now the problématique. Is harmonization possible in investment arbitration? Is it desirable? And what's the alternative? A passage in the case Burlington and Ecuador aptly distills the debate. Paragraph 100 of the decision begins by saying that the tribunal considers it is not bound by previous decisions. At the same time, it is of the opinion that it must pay due consideration to earlier decisions of international tribunals. So far, so good. From there, however, the views diverge. The majority believes that subject to compelling contrary grounds, it has a duty to adopt solutions established in a series of consistent cases. It also believes that subject to the specifics of a given treaty and of the circumstances of the actual case, it has a duty to seek to contribute to the harmonious development of investment law, and thereby to meet the legitimate expectations of the community of states and investors toward the certainty of the rule of law. Arbitrator Stern does not analyze the arbitrator's role in the same manner. She considers it her duty to decide each case on its own merits, independently of any apparent jurisprudential trend. So there we have it, assuming as a baseline that arbitrators will always decide each case on its merits. What should they do about the law? Should they seek to contribute to the harmonious development of investment law, or should they decide independently of any apparent jurisprudential trend? Now, each approach might lead to consistency in practice. The case-by-case one might get there by happenstance. But harmonization involves some sense of agency, of deliberateness by the arbitrator, and attention to the arrangement of the composition so that it produces a harmony and not cacophony. We agree with the majority. We submit that harmonization in investment arbitration is 1, possible, 2, required, and 3, unavoidable. Investment arbitrators not only can achieve harmonization, but they have a duty to do so. I will begin by explaining why it is possible, and my colleague Andrés Jana will explain why it is required and unavoidable. So first, harmonization is possible because investor-state dispute settlement is a means of public international law adjudication, and it applies principles of international law. Now, the fact that it is a form of international law adjudication is not and could not be seriously in dispute. Tribunals derive their authority from treaties, and they have a duty to apply international law. They also apply customary international law principles of treaty interpretation, as reflected in the Vienna Convention on the Law of Treaties, where their analysis typically begins. And this requires them to apply the rules of international law, which include both conventional international law in the form of the relevant investment treaty, but also customary international law. And their function is no different in that sense from what the ICJ does in other branches of public international law. And under the ICJ statute, as we know, the court shall apply judicial decisions as a subsidiary means of interpretation, that's Article 38.1, subject to the proviso that the court's decisions are not binding except on the parties, that's Article 59. Now, the same principle should apply as between investor-state tribunals, which, notwithstanding that they are an ad hoc decentralized system, belong to a common system of dispute resolution that shares the same principles of applicable law, objectives, and purpose. Treaty tribunals should therefore give due consideration to the decisions of other international courts and tribunals, even if they're not formally bound by them. And that is in fact what they do. Let me give you some examples. First, the definition of investment. It varies in each treaty, but there is a converging interpretation that has been incrementally built up over time. And some tribunals consider that it has acquired an autonomous inherent meaning in the investment treaty context. Consider, of course, the well-known Cellini and its progeny, which is even extended to non-ICSID arbitrations in cases such as Romac, which will be familiar to our panelists. Second example, it has become axiomatic by now to apply Chozo Factory and the ILC articles for the standard for compensation for breach and Mavromatis for the definition of a dispute. Other examples are denial of justice, arbitrariness, the minimum standard of treatment, measures tantamount to a taking, the binding nature of ICSID provisional measures. All of these concepts have roots in customary international law and in judgments of the ICJ. A final example, the grounds for annulment of ICSID awards. There are different ad hoc committees interpreting the same treaty language under the ICSID Convention in similar ways over time. And through this iterative process of harmonization across time, we have developed a common understanding of what these concepts of international investment law mean. And we've done that by deliberately giving consideration to their evolution, to what other tribunals have found with similar legal concepts, and whether that is an appropriate line to follow in the case at hand. And that, of course, is no different from what national courts do, in particular when applying international instruments. Any system of dispute resolution requires a minimum of certainty and predictability, and therefore it requires that tribunals seek the consistent application of the law within that system. Again, some examples, the UNCITRAL model law. It's implemented in different ways in different countries, but all courts seek a coherent application. In fact, the model law itself directs courts to do so. In Article 2A, it says, in the interpretation of this law, regard is to be had to its international origin and to the need to promote uniformity in its application and the observance of good faith. And the New York Convention is a similar example. And of course, some courts look to decisions of sister courts as persuasive authority, and that happens often within the high courts of the Commonwealth. And I would say that proof that investor-state tribunals form part of a system of international dispute settlement that applies international law is that the cross-fertilization is going the other way. Decisions of investment treaty tribunals have been cited by the ICJ, for example, in the Chile-Bolivia case, and by the CJEU, which just a few weeks ago in Castres, Moldova, considered itself competent to interpret the meaning of investment under the ECT, and the Attorney General referred to decisions of investment treaty tribunals in reaching the opinion. And with that, I pass it over to my colleague, who will explain why harmonization is required and unavoidable. Over to you, Andrés.
Thank you very much.
Thank you, Andrés.
Thank you very much, Ina. Ina has already demonstrated why harmonization investment, investor-state dispute resolution is possible, but it's also required, and as she said, unavoidable. Let me start with why it's necessary or required. Harmonization is required because it safeguards the legitimacy of the system. Harmonization fosters certainty, fairness, efficiency, and meets party expectations. These are all hallmarks of public confidence in any system of justice. I will go quickly through each of them. Certainty. As it should be obvious, consistent decisions making contribute to legal certainty, which facilitate business planning, reduces dispute ex ante, and contribute to a stable regime for investment, which is at the end what FDI is all about. One of the biggest criticisms of ISDS is that it lacks legitimacy to the extent it produced unjustifiable, inconsistent results. Indeed, consistency in the decision of ISDS tribunals is considered such a fundamental value that many stakeholders advocate for a new institutional arrangement in order to foster such consistency. Fairness. Fairness because consistent decisions result in like cases being treated alike. This is a rule of law imperative and a guarantee of equality on the treatment of the parties. To a large extent, ISDS tribunals face similar legal issues with similar applicable law that share the same principles. In front of the increased demand for transparency and coherence, harmonization is then not just possible, but also necessary. Let's go to efficiency. Why efficiency? Efficiency because the seek for harmonization means certainty and therefore predictability that permit the plan of business relations of states and investors in the long term. Again, a key goal that FDI tries to achieve. Users of ISDS see efficiency, time and cost as a key concern. Harmonization promotes those twin goals because one does not need, let me put it this way, to reinvent the wheel every time and can draw from the collective wisdom of prior cases without being bound by them. Critically, I would say, the most important point in my view, party expectation, which in my view should settle the discussion. A compelling proof that harmonization is necessary and required is reflected in the empirically established and broadly recognized practice in ISDS setting. The parties always argue from prior decisions and tribunals' reasoning consider in their decision prior cases and settle jurisprudence. Actually, it would be a rare thing to find either a submission or an award without extensive citation to past investment treaty cases. In other words, users want and expect harmonization. They expect that tribunals will consider previous decisions presented to them as relevantly similar. As a system that is derived from and depends on user needs, ISDS must be responsive to that expectation. Investment tribunals respond to that expectation by taking them into account in their legal reasoning as a necessary component of the justification of their decisions. So now that clearance is required, let's see also why it is unavoidable. It is unavoidable first because as reflected by parties' practice in arguing their cases, and arbitral tribunals in deciding those cases, the system dynamics pushes for harmonization, similar legal issues with similar legal standards in a specific area of law established to resolve the same type of disputes, and that share the same legal principles and objectives, leads unavoidably to seek a harmonious development of investment law. But such harmonization is not only seen in the role and function of arbitrators. The general trend towards harmonizations is clear in almost every front of investment law and investment arbitration. Initiatives to increase transparency. Now, publication of the awards is not a disputed issue anymore. ISDS decisions have been influenced by drafting of treaty provisions, like is shown in several of the current initiatives to upgrade, modify, or update treaties. This is reflected as well in the increased trend towards multilateral and regional agreement as opposed to bilateral ones. Even more, if we look at the proposals that are now in hotly debate in investment arbitration, we will see that these proposals consider consistency so important, they are even advocating for creating institutional system that would foster that, such as a standing in multilateral investment court or a standalone appellate mechanism. In sum, ISDS, like any system of dispute settlement, requires certainty. This is a fundamental value for its legitimacy. Without the harmonious development of the law applicable to the disputes that the system is called to resolve, such demands for certainty and legitimacy cannot be met. Therefore, investment arbitral tribunals, as adjudicators of such disputes, have a key role and function in contributing that investment law, with its distinct and different individual notes, will develop as one and the same melody. Thank you.
Thank you very much. Andrés, I think it was very clear, the position I heard words like harmonization is possible, feasible, unavoidable, necessary, fundamental for legitimacy. So I think the work for Fernando and Giuditta is quite hard.
Thank you. Thank you. Well, the way we have decided to proceed is that I will concentrate on the substantive aspects of harmonization, and Giuditta will address the procedural aspects of harmonization. And I will start, before providing some context, with a response to Ina. I mean, Ina cited a decision, a majority decision, basically using that award to say that that the harmonization was really necessary and that was almost a duty of the arbitrator. I have another award, paragraph 171 of that award. This time is an unanimous award. It's not a majority award on this point. And it's an award that I know well because I wrote it. And this tribunal, which shows, I mean, that as soon as you have the label of an arbitrator and you talk about an award, you have some kind of authority. So that's my authority. And that award, which is the Romak Uzbekistan award, the arbitral tribunal decided that the duty of the arbitral tribunal, his mission, is not less important, but is really mundane, which is to resolve the present dispute between the parties in a reasoned and persuasive manner, irrespective of the unintended consequences that this arbitral tribunal's analysis might have on future disputes in general. So, I mean, this shows that the harmony in investment arbitration is probably more as a cacophony than really harmony. But let's go back to the title of the seminar: Harmonization through arbitration, the arbitrator's role and function. So let's concentrate on that. What is the primary mission of an arbitral tribunal in investment arbitration? And the thing is to resolve the dispute or to contribute to the creation or development of law. And I think that the easy answer would say both. But no, I mean, when you have a mission, you have to put priorities. And which is really the priority as an arbitrator? And I think that no one doubts, and mostly so the parties involved in the arbitration, including the state, the mission of the arbitral tribunal is to resolve the dispute. I rather prefer an arbitral tribunal that is concentrated on the facts, on the relevant treaty, on the measures that have been attacked, than an arbitral tribunal that is concerned by how we should shape the future of investment arbitration. So the fact that probably arbitral tribunals will not simply ignore what is going to happen with the award after the award is rendered, or for reasons that I will come back later on, will be concerned about what the public will do or say with respect to the award that they are going to render. This does not take anything out from the main premise, which is that the role of the arbitral tribunal is to adjudicate the dispute that is presented. And that brings me to the second point concerning arbitral tribunals. Duty. It's the role, the mission, now the duty. Who the arbitral tribunal has a duty to? Legal. Who is paying the fees of the arbitrator? I mean, let's be basic. It's not the legal community. The arbitral tribunal, the arbitrators are not employees or are invested with a mandate like the justices of the International Court of Justice. The arbitral tribunals are there because the parties selected them, are paying them, and wanted them to decide this dispute. So any duty from the arbitral tribunal is due primarily to the parties. Putting this context first, having put this context for the analysis of the substantive harmonization in investment arbitration, let's now address the main point. When you make comparisons between commercial arbitration and investment arbitration, you said, okay, there is some sort of jurisprudence or precedent in investment arbitration because we have similarity of investment instruments, treaties are similarly drafted, and actually the standards of protection are alike, very numerous, and everyone knows perfectly what those standards are. But I mean, is this really such a big difference with respect to commercial arbitration? And I use the comparison because of the previous panel on commercial arbitration. You have situations in commercial arbitration that are very much alike investment arbitration. You have all kind of contracts that are based on form contracts, and I essentially refer to contracts that you all know, FIDIC form of contract. They are always the same format, and is standardly used in construction, oil and gas, the AIPN contract forms, which are standard forms widely used in oil and gas industry. And the issues, same thing. There are situations in which the issues are very similar, which are those issues in distribution and agency contracts, are issues that are repeated. So we are not seeing here in investment arbitration a big difference with respect to commercial arbitration. Probably the difference would be on the applicable law. When you refer to applicable law in commercial arbitration, you have different state laws that could be applicable and they could be different. In investment-related arbitration, most of the time, you have the big reference to international law. But I would say quite the opposite. I mean, it's easier with international law. The sources are very much limited. The principal source, and relying on the status of the ICJ, the principal source of law are precisely the treaties. So those treaties are quite similar indeed. But then that similarity ends there. And I just go back to one example that is very well known to Diego, because it's Argentina. In the Argentina crisis, and I give you an example that is used by everyone, the state of necessity. Same measures, same crisis, same treaty, exactly opposite decisions. So, and in one of those decisions, even with a common arbitrator, that in one situation decided white and on the other one black. So is that really harmony? Is something that we are seeing in investment arbitration? Let's go finally, and I will end with this, with the citations. It's true. It's true. When you read investment awards, those awards cite most of the time a great variety of previous decisions. But this citation means that the arbitrators are just trying to create precedent, or that they are espousing the reasoning of the tribunal. I have doubts. I think that citation comes there thinking highly because the arbitrators want some comfort in the reasoning, and they will find that comfort, but they will find that comfort whatever the result is, because they will find the decision that satisfy the point that they want to demonstrate, as counsel do when we use citations of previous awards as well. I will be less highly regarding towards my fellow arbitrators if I say that sometimes it's just for laziness. I mean, it's so much easier to refer to some kind of reasoning that have been already developed by someone else than to have to develop originally that reasoning. That is probably easier to make that citation. Now, the citation, you said, okay, listen, I can't make a proposition, and I find X number of awards, but I am sure that you will find Y number of awards that sustain exactly the opposite position. So I do not believe that the fact that we are citing more and more arbitral awards means really that we are harmonizing the law. Quite to the contrary, I think that that multiplicity of citation only shows that the decisions by arbitrators are so diverse that when you want to really confront a sole proposition, you use the other decisions as a sort of support. So for me, and I will end here, I think that there is no need for harmonization, but in fact, I think that we are not having any kind of harmonization, at least on the substantive aspect of investment arbitration today. Thank you.
Giuditta, please, before giving the floor to Giuditta, someone asked for the name of your case. Is Romak versus the Republic of Uzbekistan. It's a PCA case. Giuditta, please, you have the floor.
Thank you very much. Yes, I will turn, as Fernando said, I will turn to the question of harmonization in the procedural law, feasible and or desirable. And it would seem actually that investment arbitration is particularly apt of being a fertile ground for harmonization because of the ICSID Convention, which is a self-contained system that should therefore be feasible of an harmonized and uniform interpretation, particularly in light of these extensive use of precedents of which we have discussed. In reality, even the ICSID arbitrations, the ICSID awards do show a fragmented approach. And actually the representative himself of the opposing team made the argument that it would be desirable to have a, or at least that a possible way to avoid the fragmentation would be a centralized court, which actually means that as per today, the arbitration is quite fragmented, therefore not so very harmonized, even when it is based on the self-contained system of the ICSID Convention. But in addition to that, there was a study made by the University of Oslo very recently showing that circa 45% of all investment arbitration is not based on the ICSID Convention, the procedural aspects. They are based on the rules for commercial arbitration. So they are ad hoc concitral arbitration, or they are Stockholm Chamber of Commerce or ICC or other rules of commercial arbitration. And these proceedings, even if they are investment arbitration proceedings, they are subject to the procedural rules of the national law of the place of arbitration. And this can have, of course, differences. And the differences in the procedural rules, they may affect the validity of the award and the enforceability of the award. And even if we are talking about investment arbitration, the validity of an investment award that is rendered under the ICC rules, for example, will be decided under the national law of the place of arbitration, and the enforceability will be decided under the New York Convention, even if it is an investment award. And I will make only very quickly, only 3 examples of procedural rules that differ from country to country and that may have an impact on the validity of the investment award and on the enforceability of the investment award. And the purpose of showing these examples is to show that for at least 45% of the investment awards, there is no possibility to have a full harmonization because the regime for validity and enforceability of the awards may differ. So the first example is the maxim of the Jura Novit Curia, which means that the arbitral tribunal has the power to develop its own independent legal reasoning, independent of the pleadings made by the parties. And the question there is to what extent the arbitral tribunal may apply a legal theory without having discussed it with the parties before, so without bringing the parties' attention to that. And this is relevant to the question of validity and enforceability of the award because it affects the fundamental principles of the right to be heard, and the excess of power, which both are grounds for setting aside or refusing enforcement. And we know that there are different, I won't go in detail here, but we know that there are different legal systems who have different answers to this particular question. Do you have to draw the parties' attention to the new legal issues, or do you not have to do that? So this is one example. The next example is unfortunately very popular, or I wouldn't say popular, but in any case, it has arisen a lot of quite frequently in these last times. It is to what extent you can have a digital hearing. You know, you can't travel, therefore, instead of going all to the place of the hearing, you decide to have a Zoom meeting with a hearing. And the question is, if the parties do not agree to that, does the arbitral tribunal have nevertheless the power to compel a digital hearing or not? And here again, there is a very recent study by the ICCA, very interesting, showing that different legal systems have very different answers to these questions. And all of these differences that you have in the legal systems, they impact the right to be heard, which is the same ground for setting aside or refusing enforcement of an award. So this was the second example of different procedural rules that may have an impact on the validity and enforceability of the award. And the third one is the arbitration agreement, the validity of the arbitration agreement, even actually the formal validity of the arbitration agreement, because we know that in some countries, it is allowed to have oral arbitration agreements. In some countries, they have to be written. And there are also different definitions of the written form. So this difference, again, has an impact on the validity and enforceability of the award because it goes to the very basis of the jurisdiction. So these three examples, they are meant to show that for at least 45% of the investment arbitration of the investment awards, those that are rendered under commercial rules, there is no possibility to have a full harmonization because you have to take into consideration the legal framework. And the legal frameworks may differ from one another, and those differences may have an impact on the validity and enforceability of the award, which means that the arbitral tribunal and the parties really need to take those differences very seriously, and therefore harmonization goes in the second, gets the second or third priority, actually. So there are a lot of soft sources of soft law within the area of procedural law. And some of them enjoy a very wide success, like, for example, the IBA guidelines on conflict of interest, on taking of evidence. Does this mean that if we look away from these very extreme examples that I have made, does this mean that in less extreme areas there is room for harmonization? Yes and no, because if you look at the guidelines on conflict of interest, for example, that are really used all over the world, you have a recent decision from the High Court, I think it was in England, 2016, and one even more recent from, I think it was the Supreme Court in Austria, 2019, who had in front of them the IBA guideline, the guidelines, but decided in a different way. They found, that the green or yellow or red light, I don't remember the examples that were supported in the guidelines, they were not correct according to their own understanding, interpretation, and legal tradition. The answer was different from the one that was recommended by the guidelines. So this is something that, if we have the time, I will develop a little bit in the second round of our exchange. My summary here so far is that harmonization cannot take place when it comes to the borders of the tribunal's discretion, when it comes to the mandatory principles that affect the validity and enforceability. There it's national law, legal framework, no doubt about that. But even when it comes to the area where the arbitral tribunal actually has a discretion and where you have, for example, soft law rules, even in those areas, the legal tradition may play a very important role. So I think I will stop here for the moment, and then I will develop a little bit more this question about the scope of the tribunal's discretion in the second round, if that's okay with you, with the program.
Thank you very much. Of course. Now, so we have the possibility for a reply from Ina and Andres. Please try to go straight to the point in order to have the possibility to hear also the rejoinder from Fernando and Giuditta. Ina and Andres, please.
Thank you. Thank you very much. I will start, and I will give then the floor to Ina. I will start with the procedural point, and I have to say that I was a bit surprised because I didn't think that someone would argue, that there is a lack of harmonization or that harmonization is not desirable from a procedural point of view. So I'm a bit surprised, and I think it's it also goes against the empirical facts. First of all, in investment arbitration, you have ICSID. ICSID is a self-contained system. So at least I think Giuditta would agree with us that within the ICSID system, there is clearly harmonization, as is shown by the decision of ad hoc committees, and this is also the role that ICSID secretariat fulfills in also going through the development of the entire procedure, giving you templates, forms, etc. But still, she has the point about what happened with the non-ICSID cases. Well, at least we agree that 55% of the system at least is harmonized and coherent, procedurally speaking. When it comes to let's say UNCITRAL cases, which is the largest number, I would say that enforcement is not the right place to look, because we are speaking about harmonization through arbitration, no harmonization through the courts by enforcing those awards. Of course, when it comes to enforcement, we know we'll have to deal with local courts, but let's focus on the arbitral tribunals, which is our topic today. What I would say that when it comes to arbitral tribunals, the pool of arbitrators, again, as a fact, that intervene in both type of cases, ICSID cases and PCA cases, but also I would say in ICC cases, tend to be the same. And they have developed common features when it comes to attend to the procedural issues related to those cases. So I think that this cross-fertilization or the participation of the same small pool of arbitrators in the cases provide for that in investment arbitration there is to a large extent consistency and coherence when it comes to procedural matters. Let me just mention one last point: transparency, which I think is a good example. Now when we'll argue today that when it comes to transparency, a PCA arbitral tribunal shall not be bound to be transparent in a way investment arbitration is transparent as would be an ICSID tribunal. Actually, UNCITRAL has given the Mauritius Convention to the world, which is on somehow has created guidelines or soft law for how to handle the transparency issues. And these to large extent show again how integrated the system is. And I would say that the trend is going exactly towards more harmonization, no less. Second point with respect to Fernando's merits point, I would say only two things. I think we didn't hear any rebuttal to our point that the ASDS is a system of dispute resolution that requires certainty, and being a decentralized system, also arbitrators have a key role to contribute to the organization of that system through their decisions. We may hear something in their rebuttal. Maybe Fernando is saving that for having the last word on it. Second, I just want to mention the following. From our point of view, it would be simply inconceivable to argue that an investment arbitral tribunal has to decide the case only with reference to a specific treaty without taking into consideration the evolution experienced by investment law, in particular given due consideration to previous ISDS cases and the development of investment law as reflected on those decisions. More, the fact that there are thousands of investment treaties, each with their own language, does not mean at all that we should not or cannot have harmonization. This argument really is beside the point. Investment tribunal like the ICJ or PCA or any public international law adjudicative body will be tasked to analyze a multitude of treaties. Even so, the ICJ needs to be consistent in its decision. There is no debate about that. A different treaty text does not preclude an harmonious interpretation. Decisions in individual cases will, of course, would depend on the merits of the case, but the different treaty language is like the different notes in the harmony. Not all the same, but all form part of the same melody. Ina?
Thank you, Andrés. And I think one example can illustrate the point quite clearly. And I'd like to go back to ROMAC. I'd like to go back to my colleague's remarks about ROMAC. Now, he cited ROMAC in Uzbekistan, which I might add is a case from 2009. And a lot has happened since then in the intervening several decades. In fact, I would submit that if you look at ROMAC, it is an excellent example of exactly what we have been saying. And I have 3 points. First, the paragraph that he quoted to you, 171 from ROMAC in Uzbekistan. The suggestion there was that the arbitral tribunal's mission is more mundane but no less important. And then they say to resolve the present dispute between the parties in a reasoned and persuasive manner, irrespective of the unintended consequences, they say that this arbitral tribunal's analysis might have on future disputes in general. Now let's talk about that for a minute. First, it is, I would submit, part of that very mundane duty to motivate one's decisions, to take into account the decisions of prior tribunals operating within the same sphere and considering for the most part the very same language. So it is in fact part of that mundane obligation to decide in a reasoned and persuasive manner to explain why it is that one departs from or coincides with the reasoning of other tribunals that have considered for the most part the very same thing. The second part of that sentence says, irrespective of the unintended consequences that this tribunal's analysis might have on future disputes in general. And this is a little bit of a, we're washing our hands of the systemic implications of our decision on future cases. And I would ask you whether that is really a fair assessment of where we stand 20 years later. Can a tribunal really have that kind of Nelsonian blindness to say, we will ignore the unintended consequences? And I would submit to you that those consequences cannot anymore be unintended because we know how the system operates, because we know that parties reason from past decisions, because we know that tribunals decide by reference to past decisions, and because we know that that is what the parties expect. And in fact, they expected even more today than they might have done in 2009, witness the discussion on consistency in the UNCITRAL working group. And if you take ROMAC as an example, it's actually a really good illustration of the point, because parties even today argue, why is it that the ROMAC tribunal thought that it was a good idea to take some context from Cellini in the very specific context of the Exit Convention and purport to apply it to cases under the UNCITRAL rules that have nothing whatsoever to do with Article 25. And 20 years later, we're still having that debate. So those consequences, if they were unintended in 2009, can no longer in good conscience be unintended in 2001. And in fact, I would submit to you that even the ROMAC tribunal did what my colleague is now saying one should not do. Because if you look at a later paragraph in that decision, what they in fact did was purport to define the meaning of the term investment. This is in paragraph 207, not by reference to the specific treaty language, or rather not for purposes only of the specific language in question, but they purported to define an inherent meaning to the term, inherent meaning that goes beyond the specific treaty language in question. They say the tribunal considers that the term investments has an inherent meaning entailing contribution that extends over a certain period of time and involves some risk. And then get this, the next sentence in that paragraph says, the tribunal is further comforted in its analysis by the reasoning adopted by other tribunals, which consistently incorporates contribution, duration, and risk as a hallmark of an investment. And that, I submit to you, is not only what arbitral tribunals do as a matter of practice, but what we say they should do in order to guarantee the legitimacy of the system and to respect the legitimate expectations of the parties on which the entire system depends. And this, I think, is our closing point, and I will leave you with this. It is because tribunals form part of this public international law adjudicatory system that single observation, to which we've heard no rebuttal, suffices to justify the need for harmonization in investor-state dispute settlement. Thank you very much for your attention. We have no further remarks.
Please.
Thank you, Diego. Thank you, Ina, for having analyzed the Romaco word. I think it is important to recognize that, again, the paragraph that you cited says that it's in order to confront and to comfort the analysis of the tribunal, which is what I already mentioned before, is the only reason why normally these citations are made. But let me just answer to the initial point, the IDS as a system. I frankly speaking, I do not believe that we are talking about a universal system of law, and we can have this discussion. I mean, it looks much like the legal system of international arbitration that is so close to the French doctrine, as you know. I don't believe that that's a reason to say that we should, and which everyone participating in the arbitration, and probably I guess not only arbitrator but also counsel, should endeavor to get some kind of harmonization. I think it's irreal. First, I mean, let's go back to the authority of the arbitral tribunal to impose harmonization. I mean, there is no binding authority. Probably we could discuss whether there is persuasive authority, and then the big question is, it all depends of the person. I mean, the value of an award, it depends on the members of the arbitral tribunal, and we all know that. It's the same situation with legal doctrine. I mean, the fact that someone has written something, has been printed, means nothing. So the same situation happens with award. So there is no really authority from the arbitral tribunal to impose harmonization or to look for authorization. But then to the 3 points that were being made before, I think it is actually impossible. There is no way to control that harmonization. There is not a Supreme Court. There is no hierarchy that would control that harmonization. I don't believe that is necessary, and it's good that both Andrés and Ina has discussed about awards that have been published. I think that whatever kind of harmonization could be intended, transparency and publication of awards in investment arbitration does the job. And I finally think that is not desirable. I think that harmonization necessarily goes to sort of a lowest common denominator. And I think that the important thing in arbitration in general, including investment arbitration, remains flexibility, adaptability, and the capacity to focus exclusively on the dispute that is being decided by the arbitrators. Finally, with respect to predictability and certainty, which are words that we hear all the time concerning arbitration, including commercial arbitration, I think that predictability and certainty is not attained. I mean, when you have human beings involved, the room for surprises is always present. And I think that really when we plead and we request certainty and predictability, we are kind of requesting from arbitration what we cannot obtain even in court litigation that has recourses, that have review of the merits, and that have a Supreme Court trying to unify the law. So at the end of the day, I think that with this kind of approach, looking forward for harmonization, we are living through a sort of schizophrenia in which we want arbitration, but we want certain features that we consider that only appear and we have in state court proceedings. And that's the reason why, and I finish with this, there is so much voices now advocating for an investment court with arbitrators exclusively dedicated to investment arbitration. What a nightmare. Thank you.
Giuditta, please. Do you have anything to add, I think?
Thank you. Yes, with pleasure. I think actually the debate about harmonization is very much a question of perspective. Do you see the glass half full or do you see half empty? Why is that? Because there are some areas that are undeniably not where harmonization is undeniably not possible. And the three examples that I made earlier, where if the arbitral tribunal does not take into consideration the fact that the award will be set aside or will be refused enforcement, if the arbitral tribunal does not consider that, then he is not, or she is not doing, the arbitral tribunal, it is not doing its work properly, actually. So that is one way of looking at harmonization. It is not possible in those areas. It is not possible. Those are the extreme borders. But then, of course, there is the huge area in between all those extreme borders, in the middle, where the arbitral tribunal may exercise its own discretion. And if you focus on that area, that's the half full glass would be. Then you can say harmonization is feasible, is desirable, etc. But then the question is it really a full harmonization, even where there are no external borders like the ones that I have mentioned? Can you still confide on a full harmonization there? And this is where the arbitration community, it's true, we heard also in the first panel that it's quite homogeneous, maybe a little bit too homogeneous in the eyes of some. So maybe you can count somehow on arbitrators sharing the same sort of mentality and so on. Maybe, I'm not sure about that. To a certain extent, certainly. But what you should not forget is that the legal tradition plays a very important role. First of all, we saw in my examples earlier, the English and the Austrian courts who decided that the IBA guidelines were not, did not give satisfactory answers, and they decided in a different way. That is a good example of how legal traditions play a role. But legal traditions play a role even for arbitrators themselves. And I will make as an example the Scandinavian tradition for arbitration. In the Scandinavian countries, the oral hearing is extremely important. It is considered like an essential part of the principle of due process. And if you suggest that there should be written witness statements in advance of the oral hearing, the Scandinavian arbitration practitioners, they will look at you as if you had said something really unacceptable. Now, it's changing. There are more and more people who also in the Scandinavian countries are accepting, maybe not very happily, but still accepting this practice. But the general approach is that you should not have written witness statements. This is a typical example of legal tradition mentality. We are within the external borders, so there is no question about validity or enforceability of the award that the arbitral tribunal has necessarily to take into consideration if you want to render a valid award. There is no question about that. There is only a question of how to manage the case in an area where the arbitral tribunal has a discretion, and yet there are different legal traditions. So my point here to conclude is that even looking at the part of the glass which is half full, where there is the full discretion of the arbitral tribunal that can be exercised, even in that situation, I would not count on a 100% harmonization possibility, because the legal traditions still play a role. So with that, I will stop. Thank you.
Thank you very much, Giuditta, and all of you. I think it was really impressive as a discussion. We have had almost 130 people following by internet, so I think it's really a very good start point for the Paris Arbitration Week. I would like to make a question. It's not my question, it's from the public, and I'm very sorry if it is too late for you. Some of you referred to the Multilateral Investment Court. And the question is, if do you think that the UNCITRAL Working Group 3 is really doing its work with this proposal, in particular in what referred the criticism against the lack of consistency? I can start maybe by Fernando, that Fernando, I think, has a concrete opinion, but maybe also to Andrés, who participated, who is really involved in this thing.
Yes, I have a clear and settled opinion on that. I do not believe that, I mean, let's put it this way. If we want really to create a system that is divorced from arbitration, as we know the word arbitration mean, of course, I mean, we can create such a court and we will create a parallel court system, and that's fine. But then I have serious doubts whether we would be able to continue calling this investment arbitration. Could be investment general court, and there will be sort of a kind of a bar, an investment bar, in which a certain prominent arbitrators dedicated exclusively to investment arbitration will sit, and probably even only certain lawyers will be able to plead before that court. But okay, but that doesn't have anything to do with arbitration, and that would be probably the end of investment arbitration. But again, I think that the question concerning what UNCITRAL is doing or should do is rather better answered by Andrés.
Yeah, I rather not answer that question. It's a complex one, but let me make two comments. And I understand that we are outside the role now, right? We finished with the role. I would say I would make two comments. The first comment is an observation that we already made in the presentation, that there is a concern, and I would say a perceived concern, that the system has problem with consistency. The decentralized ad hoc system has a problem with consistency and what is more called the unjustifiable inconsistency, which is basically one of the examples, the Argentinian cases, but indeed, no. And I think that the discussion is what institutional arrangements would permit to achieve a higher consistency. And really, the Multilateral Investment Court is far from being unanimous. Actually, there are some proposals that I would say may have some broader support that suggest there may be a standalone appellate mechanism that would coexist with arbitration, could do that job as well. But again, it's a very open discussion, and it's true that the advocates behind the Multilateral Investment Court consider that several of the legitimacy problems of the system, including unjustified inconsistency, will be solved through a Multilateral Investment Court. The other point that I wanted to make is that I think at the end, the discussion has to do with the legitimacy of the system and how the quest for the legitimacy of the system is best achieved. And in that sense, I would say that the issue of consistency is at the top of the concerns of the states. And still the question is open, Diego. What will be the best institutional arrangement to achieve consistency without, of course, with the problems or I would say the side effects that may create one or other institutional arrangements? I do believe that a decentralized system like we have now, through the progress of the last 50 years, can achieve a reasonable degree, an increasing degree of certainty and I would say harmonization.
Thank you very much. I don't know if Giuditta and Ina would like to add anything more.
I can just very briefly say that I agree with what has said, that a lot of the criticism against investment arbitration these days goes to its legitimacy, and the fragmentation is an important part of this concern. I think that a lot, well, not a lot, but a considerable part of the criticism is maybe more inspired by political concerns than by technical legal concerns. So I do think that it is possible to find technical legal solutions without changing completely the nature of the system, but it seems that there is a political in the good sense, not in the detrimental sense of the word. So there is an interest in finding a different system, and there the technical legal arguments do not help actually.
Thank you very much. I have here José Feris, was
he's allowed to ask questions as well.
Yes, to you, Andrés. One last question. I want to perhaps throw in a topic which we have not covered today, but it has to do with harmonization, and I think it is very much in debate when it comes to investment arbitration, and it's the arbitrators, right? And because when you look at the solutions that are being proposed, the reforms of the ISDS system, a lot of them, if not almost all of them, relate to the arbitrators and who are the people that are going to decide. You know, the court mechanism actually focuses on who actually gets to decide and the profile these people should have. So that you see there's a lot of concern about the arbitrators. On the other hand, you also see this movement towards diversity, where there is a concern that it's the same people and you need to bring people from other regions of the world. And my question to you is, do you see that there is a clash there? You know, are we pursuing one objectives, which is to have better quality, more consistency in the decisions? Are not we putting in danger that objective with bringing people, which sometimes they may have more diverse profiles, they may be competent, but not necessarily in the subject matter?
I don't know who of the panelists wishes to give the final. Ina, maybe? Not really.
Can I, I'm still thinking about it. Can I punt it?
Diego, may I?
Too good of a question.
Yeah, please, Giuditta, please.
Thank you. I liked very much was Audrey was the expression that he was using at the beginning about male and stale and so on, and we are all witnessing an attempt to do something about that and to create more diversity. Now, that more diversity necessarily affects the competence of the tribunal. Depends on what you mean by competence, because if, as we heard also earlier, we heard that competence is often experience. So if what you are looking for is someone who has been working with male stale arbitration for 30 years, so then of course a diverse member would not have the same experience, but competence is not necessarily only that. So I would say that I would not be too worried about the contribution of diversity to the arbitral tribunals.
Yeah, I think that we cannot say that more diversity means lowest competence. I mean, that would be not only politically incorrect, but it would be not true. Now, my point here, and I'm taking...
International law. I mean, you see a lot of people coming from private sectors, from commercial law, doing now investment.
Yeah, no, but I think the point, and you're right, Jose Ricardo, is that the closest the system is, the less difficult for diversity to operate. And I think that this situation of creating an investment court and this kind of closed system goes directly opposite to the aims of diversity. And that's the reason why I am advocate so strongly for an open system, for a system that is flexible, because that's the kind of system that allows for the entrance of newcomers. And that's something that probably we all want.
Well,
Diego, if I may add just two things.
Please.
Yeah,
the very last intervention.
Oh, sorry. But if you want, I can stop here. I mean, it's okay.
No, please go ahead.
Yeah, the first thing in response to Jose Ricardo would say that first, it's important to understand that harmonization is different than correctness. And correctness is an entire different and complicated issue. You have papers written in Working Group Through and by the Academic Forum, Jose Ricardo, if you want to look at them, that discuss how to improve correctness. And of course, when it comes to improve correctness, people say that the profile of arbitrator is critical. And some people advocate for international public law scholars or people that understand international public law. Others say that you need to understand business law or understand, how understand arbitration, etc. There is a discussion there, but certainly the discussion is what is the best profile to improve correctness. But certainly the issue of correctness has nothing to do with diversity. You can get correctness, obviously, without how to sacrifice diversity. And actually, some people say that considering how the system is built or what the system is supposed to do, which is this policy consideration about the relationship between states and investors and how the states and investors, find an adequate balance, diversity is actually something good because, well, it's a system that needs different views in order to work properly, due precisely the type of issues that are involved within the system.
Thank you very much, all of you, all the speakers, all the people in the audience, physically and remotely, for the participation, the very good questions. And thank you, Leyland Watkins. And I hope that is only the beginning of a long friendship and partnership in organizing good seminars like this one. So we have with Sciences Po another meeting, a very important meeting on Thursday, the Brazilian Arbitration Forum, and we expect that the public will be also there because it is a very interesting topic to address. So see you next time. Thank you very much to all of you. Bye-bye.
Thank you very much.
Bye, thank you.